Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today is the day I earned that subscription. For today's story, we are talking about everyone's favorite lawyer, Michael Avenatti. Michael Avenatti, as you may remember, was very famous for representing Stormy Daniels. And for a hot minute there, he was even talked about as a presidential contender to face Donald Trump, because he was going to bring it. Well, not so much, because Michael Avenatti did some bad things, including blackmailing his own client, Nike, and he was convicted and he's been sentenced to prison, namely 14 years by at least one federal judge because there were more charges. Well, the federal judge has explained his reasoning for the 14-year sentence in expanded language, and I thought maybe we'd go over this to learn a little bit more about the sad, sad fate of Michael Avenatti. Let's get started with this. A federal judge has explained Michael Avenatti's 14-year sentence in a final order laying bare the disgraced lawyer's great evil. And here is a picture of Michael Avenatti in better times, when he was basically camping out in the green room of CNN, it seemed, as much as he was there, from July 2018, where he was speculating about a potential run against Donald Trump. Well, not so much for that, but maybe maybe he can run for a position in the jail or something. I don't know. They have elections there, but let's read more. The judge who sentenced Michael Avenatti to 14 years in prison on Monday explained his reasoning in a new 20-page order. The details not why the disgraced lawyer is so harsh, but rather so lenient. So, not that they necessarily need to, but the judge wanted to expand some further verbiage and explain his rationale for the sentencing. Because why did I sentence him to so much? Well, here's apparently what the judge said. As is the case with most human beings, there is an ability to do great good on an individual level, or even national or global scale. But there's also the ability to do great evil through willfully inflicting great harm on others, through greed, arrogance, lying, uncaring dealing with others, and blindsidedness. As noted above, Avenatti has done many noble and good things in his life, some reflected in this case, but he's also done great evil for which he must answer, according to United States District Judge Selina, who wrote in his final comment, the actions of Avenatti in this case and relevant conduct show an abandonment of some of the most basic principles of fairness. This is all the more tragic where he received a fine education and achieved academic excellence, was presented with challenging opportunities at major law firms, and had the opportunity to build a series of his own successful law firms. It is now time for him to pay his debts to his victims, the government, and society in general. Yeah, so Michael Avenatti climbed a wall, and then he had a great big fall, and all the king's horses and all the king's men couldn't put Michael Avenatti back together again. So yeah, here's some tips. Maybe less with blackmailing your own client. Maybe less with breaching your fiduciary duty. Not messing with the client's money is a really good tip to not only keeping your law license, but keeping yourself out of jail. Just don't mess with the client's money. It's a good thing. And don't threaten the client. Yeah. And the 14 years, though. So, yeah. Okay. The 20-page order accounts for each sentencing enhancement that was imposed on Avenatti for stealing millions of dollars from clients in a year-long fraud that turned his law firm into a Ponzi scheme. It also explained why the judge ordered the sentence not to begin until Avenatti completes his sentence out of New York for trying to extort Nike and of defrauding the client that made him famous. So this is in addition to the Nike thing. So as I mentioned earlier, not the only federal judge who has to pass judgment on Avenatti. Avenatti blackmailed Nike, his own client. In addition to that, he stole millions of dollars from his own law firm in a Ponzi scheme. So he's been convicted in both New York and California. Both East Coast and the West Coast have had a word with Mr. Avenatti, and this judge has said, how about not so much with concurrent? How about consecutive? So after you're done with the Nike sentence, how about you do 14 years on top of that? Something to look forward to for Mr. Avenatti, I suppose. Avenatti also asked for a 6-year concurrent sentence, arguing with the judge while representing himself pro se, always a good tip, during the 3-hour hearing, then asking for mercy and another chance at life during the standard allocution that criminal defendants are allowed. Avenatti had received a tentative ruling from the judge outlining thinking on the sentence, and the judge said early in the hearing that he was looking at 168 months. Well, that sounds like a lot. The final ruling notes that Avenatti's crimes in the California case occurred before Avenatti commenced serving time for the New York case. Thus, the court has discretion to impose concurrent sentences or not, and therefore not. So in the Nike fraud thing, 6 years. In this, 14 years. 6 plus 14 is 20. One of the usual bases for concurrent sentences is absent here. The present case is not relevant to the New York conviction. So one of the things that will determine whether or not you serve a concurrent sentence, although not necessarily the only thing, but let's say that it's the key standard metric. Okay, the key standard metric, right? Are these part of what's called the same criminal transaction, right? Are these part of the same series that form a contemporaneous whole of the thing, right? So you might think of this as like, I robbed a car to go rob a bank to do another thing, right? And so this is all part of one master plan, right? So the car theft is part of the bank robbery, is part of the money laundering, is part of the whatever, right? So that's one way of thinking about criminal transaction. Closely related in time and or purpose, right? They're part of a contemporaneous series of events. Well, here that's not true. These are totally unrelated, right? So they're not part of a contemporaneous series of events. It's just on the one hand, you stole money from the client. On the other hand, extorted a completely different client, at least according to this judge. Now, that doesn't necessarily preclude them being served concurrently or partially concurrently. As the judge noted, the judge does have discretion, but the judge decided to exercise the discretion with how about no. So just because they were completely separate didn't require the sentences to be separate, but the judge is like, well, this is a factor that's missing, so how about 20 years? The hearing showed that the judge's focus when considering the sentence was not why the sentence was lengthy, but how he could impose a sentence far below the standard range by the U.S. Sentencing Commission. The judge's order explained why Avenatti should receive more prison time because his victims suffered severe financial harm because of his crimes and because the victims were vulnerable. Avenatti acknowledged the wrongfulness of his conduct when he asserts that the nature of the attorney-client relationship allows for an inherently inequitable power dynamic. Understanding that dynamic, he nevertheless exploited the clients. Yeah, maybe not so much with that. Still, the judge did not agree with all the recommendations from prosecutors, including that Avenatti not be credited for acceptance of responsibility. Now, that is typically a thing that's available in the federal system. Typically, it requires you to acknowledge your responsibility prior to trial, but it does give you a slight credit to accept responsibility because, it's like, well, it's like you are saving us the cost and expense of trial. So you do get a bit of a credit. So the judge said they deserve that credit. The judge rejecting that argument, writing that when Avenatti allocated, which is admission, he admitted to every element to which he pled. That the government believes Avenatti should have admitted to more does not diminish the sufficiency. So the government thinks, well, you should have admitted to more things, but he admitted to each and every element. And so the judge is like, well, that's all that's legally required. So it was sufficient to get the credit. The judge also disagreed that a tweet Avenatti wrote after a Los Angeles Times article about defrauding of his clients warrants a sentencing enhancement for obstruction. But he concluded other factors support enhancement, including Avenatti's forgery of his former partner's signature in bankruptcy court and perjury in judgment debtor exams. Maybe less with the forging of your partner's signature, maybe less with the perjury before the court. Before 2005, the judge would have been required to sentence Avenatti in accordance with the standard range associated with the offense level, which would have actually been 22 years. But the Supreme Court, of course, ruled that those requirements are actually now just suggestions. And so a judge can depart from that. So the judge departed from it by going to 168 months, including mentioning that Avenatti's mother once physically attacked him. So actually, as it turns out, the judge sentenced him to less than his sentencing recommendations suggested, although giving him concurrently. So he's actually saying, why I'm giving you a break. So that's how bad it's going for Avenatti. The court also takes into account the lengthy and successful career and many favorable results he obtained for the client. The court considered substantial charitable activities. The court also takes into account a difficult childhood and perseverance to educate himself working full-time. Through his standby counsel, Avenatti has filed a notice to appeal of the sentence, which, good luck because you're below the guidelines. He also filed an objection to any issuance of a post-sentencing decision, explanation, or memorandum, saying the appellate notice divested him of jurisdiction. No, it doesn't. The judge can further explain his reasoning. It's like you're allowed to appeal, and but the judge can continue to explain his reasoning. It's like, the court will hear your appeal, but it's part of the record. The Court of Appeals can ignore it or not, but they probably won't. The judge quickly rejected this argument, saying it's frivolous, which it totally is, because it relates to things that was before the judge. It's like, just because you filed your notice of appeal before I got around to finishing my sentencing memorandum, no. A notice of appeal filed after court announces a decision, sentence, or order, but before entry of judgment is filed as of the date of the entry. So the rules already account for this. As to one of Avenatti's victims who spoke at sentencing, Gardner testified at the sentencing hearing that he was living in her car when Avenatti started representing her in a dispute with an ex-boyfriend who's an NBA player. He negotiated a $2.75 million settlement, but as established at trial, he never sent the client a share of the money. That's a problem. That's a problem. You can't do that. I'd like to represent you in your dispute with the ex-boyfriend, an NBA player. Good news, we got $2.75 million. Bad news, I'm keeping all of it. No, don't do that. Instead, apparently, he used the $2.5 million to buy a jet with another client, which was then seized by federal authorities, then spent a much smaller amount of money on Gardner periodically while telling the client that they were withholding the money. So he's saying the reason I can't pay you is because I don't have the money, because they aren't giving it to me. But they did. They cut him a check and everything. He just used it to buy a jet. That was not within the fiduciary responsibility of the attorney. To buy a jet was not one of the things to do. As to another of Avenatti's victims is a person named Johnson, who hired him in 2011 to sue the Los Angeles County after he became paraplegic when he tried self-harm in jail following abuse by guards and inmates. Avenatti secured $4 million in settlement, then paid Johnson $900 and $1,900 every month for 4 years while lying about the settlement. $1,900 times 4 years is not $4 million. Johnson lost his Social Security benefits after Avenatti didn't respond to the office's questions about the settlement. So here's a guy who won $4 million in damages from Los Angeles County, and Avenatti paid him like $2,000 a month for 4 years, which is much less than he was entitled. Yeah. A different client was a businesswoman who Avenatti secured a $1.6 million settlement. But Avenatti never gave that client a share with the money. Instead, he lied for months as they continued to spend time at the law firm and hosted a watch party for Avenatti's appearance on 60 Minutes. Nice. Restitution has also been ordered for each client. Not sure how much money Avenatti has in any of his assets, but at least we have ordered it. So good luck on getting it. But yeah, so Fan owed $4 million. Johnson is due 1.6. Gardner is owed $1.47 million. And Barella is owed $633,000. Thus, that brings us to the end of discussion of creepy porn lawyer, who just got 14 years on top of 6 years for blackmailing his own client, Nike, for the 6 years. And in the case of the 14 years, stealing millions and millions of dollars from his own clients to enrich himself and buy jets and all kinds of stuff. And because, I don't know, reasons. So it turns out creepy porn lawyer may have some slight character issues. So, yeah. So for the next 20 years of time, he will be spending some quality time at the expense of Uncle Sam. He has to pay restitution for whatever money he does have. And Mr. Avenatti, we bid you adieu as we bring an end to the discussion of this case.